Welcome everybody to yet another episode of Law Scope. In today's video, I am Sana Parvez and I am the legal expert for Hitbullseye, and in today's video we shall be discussing a few of the recent legal updates of the month of April 2023. Besides, there were some legal updates with regards to the Arif and the Saras case, where Wildlife Protection Act was extensively discussed. Then there was another case where in Prasant Sahu versus Charulata Sahu, in which the 2005 amendments of the Hindu Succession Act were extensively discussed, and the retrospective effect of the law was discussed in the same. And there were some other cases. Let us dive into what were the main cases of the month of April. So we shall be starting first of all with the case of CBI, that is the Central Bureau of Investigation versus Aryan Singh. This is a case in which the Supreme Court delved into the ambit and the scope of the jurisdiction conferred to the High Courts under section 482 of the CRPC. The CRPC contains the code of basically civil procedure, as the name says it all. In this, there are 484 sections, and in 482nd section, that is one of the last sections, it has been given that the inherent powers shall be lying with the High Courts. So, the inherent powers, let us have a look at what the provision says in this regard. Section 482 of the CRPC states that saving the inherent powers of the High Court, nothing in this court shall be deemed to limit or affect the inherent powers of the High Court to make such orders as may be necessary to give effect to any order under this court or to prevent abuse of powers. Any order that may be one necessary, and any order that is required to prevent abuse of law, abuse of the process of any court, and to meet the ends of justice. Now, to meet the ends of justice is also the phrase that is used under section 151 of the CPC, that is the Code of Civil Procedure. So these are essentially the inherent powers of the court, and because CPC, that is the civil matters, are as you all might know, of a wider ambit, a wider subject matters, etc. That is why the inherent powers are given to each and every civil court. But in the matter of criminal courts, these inherent powers to do anything that is not categorically written in letter in the CRPC, but is required for the courts to do in order to meet the ends of justice, is given only to the High Court and not the Sessions Court and not the magistracy courts, no other courts basically. If we talk about how these inherent powers are different from the inherent powers of the Supreme Court under Article 142 of the Constitution, then it is very important to note that under 142 of the Constitution, the Article 142 of the Constitution, it has been stated that the Supreme Court can do anything to give complete justice to the parties. So it is essentially in the nature of curative petition, in the sense that the Supreme Court is required to do anything to bring about justice, and it can be it can be something that is bringing about the end of justice without being contradictory to the public policy, but at the same time it does not have to be anything, or it cannot be contrary to it can even be contrary to the statutory provisions. So not contrary to the public policy, but can be contradictory to the statutory provisions. Here in section 482, what has been written, the powers that have been given to the High Court, you cannot go against the public policy, as well as you cannot go against the statutory provisions at all. So if we talk about this case, mostly this section 482 has been most widely used in order to quash FIRs. So in order to quash the proceedings where the proceedings have been basically frivolously instituted against a party, in order to harass a party, in order to do any kind of malicious prosecution or false imprisonment of any nature. So in fact, so much so that state of Haryana versus Bhajan Lal is one case about quashing of FIRs under section 482 that forms the locus classicus on section 482, and it is the most widely used case in the most widely used or most widely quoted cases in the criminal laws. So if you have to understand basically what is the quashing of FIR, we have to understand that in this case, basically in the case of CBI versus RN Singh, it was held that at the time of seeing whether a case needs to be quashed or not, when the case in FIR has been instituted and the case goes to the High Court, and a case against the FIR is instituted in the High Court, that the case is absolutely frivolous and the FIR should be quashed, then what the High Court is required to do at that point of time is that it is required to see prima facie whether the case should be quashed, the FIR should be quashed or not. Meaning to say, it should be able to see, yes, that the prima facie the FIR is looking very absolutely frivolous, etc. And it is not required to conduct a mini trial at that point of time. Why? Let us try to understand. Suppose an FIR is instituted at this point of time, or even if the case is not instituted by the institution of an FIR, by the registration of an FIR, or even if it is instituted under a complaint, say, at this point of time, then the complaint or the complaint will be inquired into and the FIR shall be investigated into or inquired as the judge might decide. So after the inquiry or the investigation, charge sheet will be created at this point of time. A charge will be created by the judge at this point of time, and the judge is only going to create a charge if he is of the opinion that there are sufficient grounds, that are sufficient material that is there on a prima facie seeing the case, that we can go ahead with the commencement of the case. So commencement of the case essentially starts from here, and here all the evidences will be seen and the cross examination will be held. So here this is the place where we are going to minutely go into the evidences. Here in this region, we are going to only see whether there is a prima facie case that can be constituted against the party or not. So essentially, if we have to delve into basically conducting a lot of seeing a lot of evidences, conducting a lot of researches, and conducting what the Supreme Court in this case say, basically a mini trial at this stage only, then the whole purpose of investigation is lost, because investigation again is only to see whether there is a prima facie case or not. So this power, basically in this case, the Supreme Court held that the power under section 482 shall be used only in extraordinary circumstances and only be used sparingly and only be used where there is a very prima facie frivolous case, and should not be used if the court will have to go into conducting essentially what we call a mini trial. Then let's come to the next case, that is Ghazi's Saaduddin versus the state of Maharashtra. This was given by a bench of Justices Sanjay Kishan Kaul, Ehsanuddin Amanullah and Arvind Kumar. In this, basically, the question that was put in front of the Supreme Court was whether the minorities, that is the Christians and the the Muslims, should be given on the basis of untouchability, on the basis of them having been converted into the different religions at different point of time. Should they be given the benefit of belonging from SCs, STs or not? So essentially what the question, the issue in this case was that basically under section 341 of under article 341 of the Constitution, some reservations can be given to some people who are basically who are basically scheduled caste or scheduled tribes. So the courts, the state, the governments can have special provisions for the SC, STs and the in other socially and economically backward sections of the society. Now, these economically weaker sections, if we talk about the Scheduled Caste Orders of Act of 1950, if we talk about that, only the scheduled castes that are included in that are the Hindus and the Jains, and later on in 1950 this was made, and later on in 1956 the Sikhs were also included in the same category. So basically any person who is a Hindu can be a scheduled caste, any person who is a Jain can be a scheduled caste, and any person who converted to a Sikh can also be a scheduled caste. However, there are people who converted into Islam or Christianity. From them this status has been deprived of being. So essentially for all practical purposes, they still carry on the social stigma with them of having been an SC at one point of time. The social stigma is with them, but at the same point of time they're bereft from the advantage or the benefit that is conferred on to the other categories or the other classes. So in this case, this issue was discussed, and the Supreme Court discussed the Ranganath Mishra Commission report. This report, the Ranganath Mishra Commission, if we talk about it, it was constituted in the year 2004, and it gave its report in 2007, stating that the social and religious stigmas are two different things, and we need to understand and bifurcate between the same, and we need to understand that these people who converted also still carry the stigma with them, and that is why they should be given the benefit of reservation. But at the same point of time, the central government rejected the findings of the Ranganath Mishra Commission report. Here, when this thing was discussed again in the Supreme Court in the present instance in the Ghazi Saduddin case, it was the central government in fact, it was observed by the Supreme Court that the central government was relying on documents that were by Britishers, documents that were centuries old, and they had no other new documents to rely on. Basically, they had already rejected the Ranganath Mishra Commission report, and they were awaiting another commission report that has a commission that has been constituted only 2 years back, that is the Balakrishnan Commission. So the government stated that we are still awaiting the Balakrishnan report, and we cannot do anything with regards to the finding or giving reservation to the SCs of other communities till the answers of the reports are there. So in this particular case, the bench stated that the government is taking a very casual approach in this matter, and basically the case has not been finally decided. But what is important is that the Supreme Court laid down this rule that social and religious stigma are two separate things, and social stigma might even continue even if a person has undergone a religious conversion. Now let's come to our third case, the state of Maharashtra versus Renuka Shinde. This is a case in which the Supreme Court discussed about the death penalty and the provisions of pardon that are given by the state government or the central government. Basically, if we talk about the facts of this case, what happened was that the accused was guilty of killing as many as 9 people. He was guilty of murder, and he was guilty of a murder of rarest of rare case, and that is why this person was given death penalty. But at the same time, there was a lot of lax in giving execution of the death penalty, and the person had been languishing in jail for a really long time. So because of he had basically filed a mercy petition as well, and the mercy petition had not been entertained by the government. So there's a rule that mercy petitions should be decided at earliest possible, and basically justice delayed or justice denied. And not only does it cause harassment to the person who has undergone, who's basically the victim of the family of the victim, but it is also a kind of harassment to the person who's the accused and is being languished in jail in apprehension of the execution of his death penalty. So in this case, the Supreme Court noted that no wonder when we see that a person the death penalty of a person should be pardoned or commuted or anything like that, what are the requirements, or what are the checks and balances that what are the requirements, or all the essentials that we're required to see are the heinousness, the gravity of the crime, the nature of the crime, whether the crime falls under the rarest of rare cases or not, but also if that person is the breadwinner of that of his family or something like that. Also, another factor is that if there is an inordinate delay in entertaining his mercy petition or not, and if all of these cumulatively, if there's a if there's a balance between all the factors here, a person's death penalty can be commuted. In this particular case, the High Court had, first of all, let us first of all discuss. Death penalty is basically death sentence. Under IPC, it can be given in the cases of, say, murder, in the cases of waging war against the country, in the cases of furnishing false evidence, which results into somebody's death penalty, and then appeasement to suicide, where a person ends up committing suicide, and also in the cases of dacoity with murder. So in these kind of instances, death penalty can be given to a person. And death penalty, what are the pardons that can be given, or what are the how can the death penalty be shortened under a mercy petition? So death penalty, the state government as well as the central government both have the prerogative, the power to reduce the sentences in form of by the president. It can be done by pardon, respite, reprieve, commutation, or any of such measures. So pardon is basically wholly absolving the person of undergoing the sentence. Pardon can only be done under death penalty. A complete pardon can only be given by the president. In this particular case, the mercy petition had been applied to the state government, and the mercy petition was for commutation. Commutation is basically changing the nature of the sentence that is being given. So, for example, a person has been given death penalty, he can be given life imprisonment now. If a person has been given life imprisonment, he can be given an imprisonment of a certain term or a fine, or basically changing the nature of the sentence. Then remission is shortening the years of sentence. Reprieve is basically suspending the sentence in order to give an opportunity to the person to prove his innocence. And finally, basically, in this particular case, commutation was done by the High Court, and the High Court stated that the High Court did the commutation, but at the same time, the Supreme Court, while agreeing with the fact that the commutation should have been offered to the person, also said that you cannot really shorten the sentence. And if you're shortening the sentence, it is said basically to the state government that if the state government is really shortening the sentence, first of all, it cannot really shorten the amount of sentence if the guilt is a rarest of rare case, and at the same point of time, it has to see that all these petitions are not delayed. They are usually delayed from about 10 years to 7 months. So these should not be delayed, so that later on a convict of a rarest of rare case cannot take the advantage of these factors. So let us take a look at exactly what the court said. Before we part with the present order, we observe and then direct all the states and appropriate authorities before whom the mercy petitions are to be filed, and or who are required to decide the mercy petitions against the death sentence. Such mercy petitions are decided at the earliest. Now, so that the benefit of the delay is not in deciding the mercy petition is not accrued to the accused, and the accused is not benefited by such inordinate delay, and the accused may not take any disadvantage of the same. Now let's go to our next case, Pramod Singla versus Union of India. This is a case of by the bench of Justice Krishna Murari and Justice V. Ramasubramaniam. In this particular case, basically what happened was that there were a number of people who were indicted under the Coffee-Posa Act for smuggling of gold outside of the country, that is to the country of China. Now, what happened was that under the Coffee Posa Act, these people were detained. The accused were detained by the police authorities, by the law enforcement agencies. Here, when they were detained under the Preventive Detention, basically under the Preventive Detention laws. If we talk about the Preventive Detention laws, Article 22 talks about the rights of an arrested person. Article 22 states that a person shall not be arrested without being informed of the guilt that he might have done, firstly. Secondly, when a person is arrested, within 24 hours he shall be produced in front of a magistrate, so that there is no illegal detention, there is no third degree torture of any sort by the police in the police custody, etc. And thirdly, what is important is that a person cannot be detained without any knowledge of his guilt, etc. And a person, if he has to be detained under the preventive detention, there are two categories. First of all, if he's an enemy alien, and secondly, if he's detained under the preventive detention laws. In therein also, the maximum number of days for which he can be detained is 3 months. After, if he has to be detained for longer than 3 months, then an advisory board of the High Court is constituted, and that advisory board of the High Court suggests to the state government or the central government whether there is any requirement of preventive detention or not. So a similar board was formed in this particular case against the accused also. Here, what were the observations of the Supreme Court? Let's see. Application of preventive detention law should be proper. Application of preventive detention law should be strict. Second, there should not be any delay in representation. So basically, the accused had already made a representation as to asking why they were indicted and asking why they had been arrested and all, and there was a delay of as many as 60 days. So 60 days is a big delay in preventive detention laws, and therefore they should be treated with in an expedited manner. Thirdly, supply of illegible documents causing prejudice. So basically, when the accused, as we already discussed under Article 22 of the Constitution, it has been said that a person who has been taken under preventive detention has to know the grounds of his arrests, basically. So the grounds of his arrest, when they were told to the people, they were furnished with some documents, and the documents were in Chinese, and not all the accused knew Chinese, so they were again in the dark as to what crime they have done. So this is something that should be at all costs avoided. Let us see the ratio that the Supreme Court gave in this case. Every procedural rigidity must be followed in the entirety by the government in the cases of preventive detention, and every lapse in the procedure must give a rise to the benefit of the case of the detenue. So there's, if any lapse in the procedure, the benefit of the doubt will be given to the detenue always. The courts, in the circumstances of preventive detention, are conferred with the duty that it has been given to the utmost importance by the Constitution, which is the protection of individual and civil liberties at the highest pedestal. Now let us come to the last case for this session. This is a case of Madhyam Broadcasting versus Union of India. The bench was CJ D.Y. Chandrachud and Justice Hema Kohli. So as you might all know that in the recent Freedom of Press Index, our ranking has gone down to 161 out of 180 countries. This is the lowest that basically we have hit in some time, and this case has become a hotspot because of the same as well, because of the freedom, because the nation is asking whether the journalism is free or not. So in a similar case, in Madhyam Broadcasting Limited versus Union of India, basically I'll tell you a little bit of a background of the case. basically what happened in 2020, the Madhyam Broadcasting Limited has a channel in the South India called the MediaOne channel. The MediaOne channel was one of the fewest channels of the national, one of the fewest national channels to have covered the 2020 Delhi riots, and no other channel did cover the Delhi riots. So after that, once all these things were broadcasted, after a couple of years, the uplinking license of MediaOne lapsed and they applied for renewal of the license. Basically, an uplinking license has to be taken from the Ministry of Information and Broadcasting, and the Ministry of Information and Broadcasting, after it gives you the license, it basically allows the channel to uplink its video, basically send the information to a satellite so that it can be broadcasted easily, or it can be telecasted to the public. So the license was essentially disallowed by the government. Now, when the MediaOne, when the Madhyam company, basically the Madhyam Broadcasting Limited, filed a case against the, filed an objection against this in the High Court, basically they filed an objection on the saying that we need to know exactly what rules we are not following. In the response to the same, the central government stated that the Madhyam Broadcasting Limited was guilty of showing anti-establishment news to the public. When asked what news was so anti-establishment that MediaOne had given out, the Supreme Court stated that the papers, the evidences cannot be showed in the court because they were of for the benefit of national security. So in this case, we need to know two provisions of law. First provision of law is Orde Alteram Partem. Orde Alteram Partem is a principle of natural justice which has three facets. First of all, the other party, this is basically Orde Alteram Partem, here the other party. The other party should be given all the information on against, if an action is being basically taken against him, that party should have all the information so as to adjudge, so as to say whether, so as to prove whether the party was right or wrong. First, give the other party all the information, then give them time to prepare their case, and thirdly, hear their case fairly. So in this case, MediaOne had the contention that if we are not shown what we did wrong, how can we defend our case firstly? And second provision that we need to know is Section 124 of the Indian Evidence Act, that basically states the privileged documents and the privileged communication of the government. Basically, it states that if there are any classified documents, if there are anything that are in the national interest, in the national security interest, in the interest of the sovereignty of the country, or anything like that, basically any secret official documents, and they are being called for in the court, then the government can simply deny to show them in the court. So here the bench, basically this was the conflict of interest, that at one point of time you have Orde Alteram Partem, and second, the central government is contending the national security laws and all these things. Here the bench of CJI D.Y. Chandrachud and Justice Hema Kohli stated that there has to be a balance between the both. So whenever the state government or the central government is alleging that there is some national security threat, then the judges cannot just take it on their word, and they have to essentially see what threat is there and how much of that document the general practice should be that they should allow the document, the judges should allow the document to be shown to the other party, but only in the cases, only those part of the documents which should be remained a secret or privilege, only those parts should not be shown, and it is the right of the other party to have essentially all the information, firstly. Secondly, the Chief Justice very famously showed his detest for seal-covered jurisprudence in this case and stated that if everything has to be done under the wraps, then it is defeating or frustrating the very purpose of natural justice only. So here the bench gave out a test of 4 things. First of all, where a state government or a central government is alleging that there is some kind of a threat to national security, and that is why we cannot furnish the document, then first of all, first thing that has to be seen is whether there is a legitimate reason, whether there is a legitimate object for them to hide the documents or to not show the documents in the court. Secondly, whether there is a reasonable nexus or a reasonable connection with what is sought to be achieved. Thirdly, whether and how much necessity is there to not show the documents, and fourthly, whether there is a proportionality between the threat that is being caused and the right of the other party, that is the right under Article 19 of the Constitution. So the test of proportionality, for this test, the bench referred to Anuradha Bhasin versus Union of India in a case of 2020, where it said that the government cannot take excessive steps in the garb of national security, and that is why, after having perused all these tests and after having perused what were the documents under the seal covers and all, the Supreme Court was of the opinion that the MediaOne ban should be lifted, and finally it lifted the ban on the news channel. So that is all for today. If you like the video, please do like the video, comment if you do have any doubts, and we shall meet again with some other interesting topic of law, with some other interesting topic in which we'll delve into other aspects of law. And for that time, goodbye, take care.